Okay, good morning. We're on the record. If you could please state your appearances.
Good morning, Your Honor. Anita Webster, and I'm here on behalf of the plaintiff who's also present, bar number 1221.
Good morning, ma'am.
Good morning, Danielle Dawson, bar number 1112 on behalf of James Fitzpatrick.
Good morning, sir. All right, so I know you've had some time to talk. So what's the status?
Your Honor, we did come to an agreement. The parties do have a rental home, and the parties have agreed that they're going to sell the rental home. I don't have the address. What's the address? Do you know?
2672 Rue Marquette.
New Market?
Rue Marquette.
Rue Marquette. So the property on Rue Marquette. We've agreed to sell it. Danielle's client is going, the defendant is going to provide 3 names of non-family member realtors to my client, and then she'll have an opportunity to interview, choose one of the 3, and then we'll get the home listed as soon as possible once the tenant removes herself.
There is a renter in the home, and so we just need to get her out, get it fixed up, and then it'll be listed as soon as possible.
Yeah.
Okay.
And if the parties do have a dispute as far as what the amount should be, we're going to lean heavily on the realtor to see what the realtor suggests as far as the listing price and any periodic reductions that need to be made according to the realtor if the parties can't agree. And then any proceeds, if we haven't reached an agreement about the proceeds, we'll go ahead and divide those 50-50 and put them in our respective trust accounts pending further order or agreement.
Okay. Anything else?
That is the extent of what we've agreed upon.
Okay. All right, whenever you're ready.
All right, thank you, Your Honor. Your Honor, this is our motion. My client is currently in the marital residence. The defendant has moved out of the marital residence, and she has requested that she be granted exclusive possession of the marital residence. It looks like from the moving papers that their response to our moving papers that they are agreeing to that. Also, the defendant has been paying the expenses related to the marital residence. There is no mortgage, but he's paying the HOA, he is paying the utilities, and I believe that he's in agreement with that as well. Danielle can address that, but my understanding is that he does agree to continue to pay that. Also, on the rental home, once the tenant leaves, husband is agreeing that he will continue to pay the mortgage pending the sale of that property. So those things look like they're set.
I'm sorry, he'll pay the mortgage on what?
On the rental home,
Okay.
pending the sale. The things where we don't agree, and I think he does also agree, we'd ask that he put the credit card back on file again for my client's prescriptions. It's my understanding he has done that now, so that was a problem, but that's been resolved. And health insurance, that he's going to continue to maintain her health insurance during the pendency. I believe that's resolved. And so the area of dispute is spousal support for my client and attorney's fees. So as far as spousal support is concerned, from his income, we see that he has $5,620 of income. There's his Social Security and a pension. With the rental income that's now going to go away, there may be some portion of that that's no longer there, but at least he makes significantly more than my client. Her only source of income is from babysitting. She makes $12 an hour. She babysits 8 hours a week, and so she makes approximately $300 a month. She was babysitting in December, and then she had knee surgery, so she was unable to work until just this week. She went back to work again babysitting. So she's had 0 income since December from babysitting, and that is her only source of income. She has an account, a checking account with some proceeds in it. She's been relying upon that, but literally her only source of money for food, for gas for her car, for any incidentals that she has, all of that's all of the money in the world that she has is the $300 and some that she gets from babysitting, and that's completely dependent upon her being able to go to the babysitting job. Whereas he does have his Social Security and he does have his pension income. So that's the main area of contention. He has indicated that he thinks that she's taken money from his account. He indicated that he was served with a complaint when he was just recovering from cancer surgery. None of that's true. His attorney at that time accepted service of the complaint. My client was with him when the doctor said that he was cancer-free, so that whole narrative in his opposition, we don't know where that comes from. My client does suffer from cerebral palsy. She does have many strokes that she's been suffering from. She did have a total knee replacement, as we indicated, and was out of work for until just this week. She does have tarsal tunnel syndrome, and she does need to have surgery on her left foot, but they're waiting for her knee surgery to fully recover. So she is going to be in a period of time where she is not able to babysit again, and she is going to need a cardiac monitor. So she's in a very bad way when it comes to her health, and that's why we had asked for spousal support of $2,000 per month. That represents less than half of his monthly income from all the sources that he listed on his FDF. When it comes to the attorney's fees, she did put $5,000 on a credit card, and he also paid attorney's fees. He indicates in his FDF that he paid only $1,500. That's not true. He paid his prior counsel $4,100, and we attached as an exhibit the bank account showing that he had paid the McDonald Law Firm $3,500, then another $500, then another $100, so a total of $4,100. He then used money from his TD Ameritrade, and it looks like $4,000 came out. I'm assuming that it went towards payment of the attorney's fees. So he's paid much more than what he's indicated on his FDF, and that's in addition to whatever he's now paid Ms. Dawson and her law firm. They indicate $1,500. I don't know if that's true. I have no proof, and I have no paperwork showing that other than what he's put on his FDF. But she has no ability to be able to keep up with him without liquidating savings, and very meager savings at that. So we really are in a position where she's still paying on the credit card, so that's the other problem, is he's able to pay his credit card off. She hasn't been able to. So we did ask for additional attorney's fees, sufficient money to be able to pay off the $5,000 credit card, and then additional $2,500 to be able to keep her going in preliminary fees. So spousal support of $2,000, preliminary attorney's fees of $7,500. And again, we went through his FDF. He listed a lot of expenses that he isn't actually paying. He indicated that he pays $600 for food and groceries. The combined total for both parties when they were together was $700. He indicates that he's paying for pest control, which he's not. He indicates that he's paying for the pets, which is what she pays, the $150 per month. He indicates that he's paying for security. There's a doorbell in front. That's the extent it has. It goes to his phone. He indicates that he is paying for dry cleaning. There's no dry cleaning. So just some expenses that he listed on there. And after we backed all of those out, he does have extra money left over in terms of thousands that he could contribute to her expenses, so that she isn't trying to live on $300 a month for all of her expenses.
Your Honor, the agreements of the parties have been pretty much accurately reflected. My client has agreed to continue with all the bills and maintenance for the marital residence. But he's going to have to take on the entirety of the mortgage for the rental property. That's the only property that they have a mortgage on.
Isn't part of that from the renter?
So the renter is no longer going to be there. She made a call this last week saying that she cannot pay next month's rent, and so he's going to have to take that on, and that is the income is how much different. So the renter was paying $1,450, and the rental mortgage was $1,300. So there was a $150 surplus that's not going to go away. It's going to be a $1,300 negative on his side of it. So he is going to have to pay that because that's the income that's coming in. So his income is actually $4,000 approximately when you back out that rental income that's no longer there, and really wasn't there because it's not. There's $150 income, not $1,450 net income, and so that's part of the diminishing of the income of my client. Plaintiff is asking for $2,000, which is half of the income of the parties, in addition to all these bills. If that were accomplishable, my client would be left with a negative number for his monthly bills. Plaintiff goes through the FDF and cites that my client's being unreasonable on his detailing of $600 a month for food, yet her own FDF states that she pays $750 for herself for food, groceries, and restaurants. Fuel of $300 a month. There's significant inflated assets here too. Clothing and shoes of $100 a month. This was not the standard of living that the parties abided by during the marriage. They have a fixed income and have had a fixed income for the last several years since my client retired. The other issue with plaintiff's statement of her own income is that she's not listing the pension that she gets every month. She listed it in her FDF as an asset, not monthly income. Yet she says that there's monthly income on her assets.
Your Honor, I can clear that up. There is no pension. She's not entitled to that pension until 2023, and then she'll get $79 per month.
Is that the Jewish Federation pension?
Yeah, uh-huh.
So she doesn't get it now?
Correct.
Okay.
Okay, so that's the other issue that exists with the financial situation of the parties. My client understands that plaintiff hasn't worked throughout the marriage, but their finances only allows for so much. He's not paying rent currently because he's living in a shared bedroom, or not a shared bedroom, but a lone bedroom of one of his grandchildren with his son. That's not a permanent situation, and it's by far not the standard that my client was accustomed to during the marriage. And he needs to get his own rental residence. He needs to get his own rental bills to be able to regain his footing from when he left the residence. He's not asking to get back in the house. He's just requesting that things be equitable pending divorce here. So that's that's their finances currently. Plaintiff has been living off of her own accounts since their separation, and she's saying that now she has additional income to be able to buffer her until this goes forward. Based on that, and based on my client's income of a total of $4,000 a month, there's just simply not the funds left to pay an additional award of attorney's fees pending sale of the rental residence. Once that sells, completely different story. We've got $1,300 freed up to be able to equalize between the parties. As to the attorney's fees, he did pay a retainer of $4,000 to Brandon. That $4,000 was used to file an answer and compile, well, to receive documents from my client. There's no indication that he ever did anything beyond taking the documents from my client. We have not been able to get a final billing from Brandon to see what was actually spent of that $4,000, but there should be a bulk of it that is still available based on the work that's been done. My office has only received $1,500, and I would not let a client lie about how much they paid me in a financial disclosure form, so that is accurate. So, until we can figure out how much exactly a former counsel used to do the work that he did, which was minimal, we can't ascertain how much his actual fees were, but I can certify to the court that at minimum $1,500 is what he's paid and what's been used. That's a far cry from $7,500, or if we're talking about an additional $7,500 onto the $5,000, that's $1,250 in attorney's fees that's been necessitated. Parties have 2 houses, minimal retirement accounts, and 2 cars. There's not extensive discovery that needs to happen. Of the assets that are existing, the biggest question is whether there's a separate property component to them. My office is in the process of compiling that information, but this is not a case where we're going to have to do extensive discovery as claimed by plaintiff. And so I just don't see how that $12,000 can be justified. The other issue that we have is that we have this house that's got significant equity in it that's going to be up for sale. The attorney's fees could easily come out of that if they're justified. But we're asking that the court wait and see how much is actually justified by the work that's been done on this case, and not issue a preliminary award of $7,500 or $2,000 spousal support at this time, based on the minor issues at hand the small income that's available to the parties and what's currently been paid by my client.
So what exactly is your client gonna pay?
He's paying
We
the
go down the list.
rental residence.
Okay.
He's paying let me pull his FCF. I apologize, I don't honestly have it here. So the mortgage on the rental residence. He is paying water.
So this is for the house that plaintiff's in, right?
Calendula house. that,
Okay. Okay. So water.
Yes, water. He's paying sewer.
Oh, there's a sewer
Yeah.
fee.
He's paying sewer. He's paying
Everything.
gas for the home,
Taxes.
power, taxes, and insurance for the home.
Okay.
HOA.
And Your Honor, my understanding with the rental residence is that we don't know how, as far as I know, she's still in the home and she's still paying the mortgage. It's just going to be that she's indicated that she's going to have to move out. So hopefully they'll be able to sell the home very quickly. I would imagine that at most he may have to pay a month. But if they price the home right, the market right now is just so easy to sell a home that homes are selling within days, literally, of being listed if they're appropriately priced. So
Okay.
They should be able to sell it quickly.
You weren't done though, were you? I asked you a question. I'm sorry.
Yeah.
So are all the expenses with the home, does that include internet and cable?
Yes.
Yes, it does.
Okay, so everything, so plaintiff's staying in the home, and the defendant's gonna pay all those expenses associated with the house, right? Okay.
So lawn care, security system, things like that.
Oh, there is no.
I don't see any security or lawn care listed on
There's
I-
lawn care
I,
listed on his.
on husband's hers?
Yeah, there's no lawn care, right? No lawn care, yeah.
You don't have a.
Okay, and then what about auto
He's also paying
insurance?
auto insurance for
Okay.
both parties. Sorry. I'm just double checking.
What about cell phone?
Yep, that's both parties.
What about credit cards?
I think there are some credit cards that are in her name only that he doesn't have access to. Is that correct?
That's
Yes.
true.
Okay.
Her name, main name.
So what's not being paid for the plaintiff by defendant is her credit card payments, food, fuel for a car,
And pet,
and pets. Okay.
and any incidentals. Car repairs, anything that she wants to do incidental to that.
Got the 2012, right?
Huh?
Which one is hers? The 2012. She's got the 2012 Mercedes. There shouldn't be too much money.
No, she has the 2008
2008. Okay.
Mercedes, which is my car.
And in 2012 is my car.
Okay.
Pest control.
Hmm?
Pest control.
No pest control. No, they have no pest control.
I do it, but I do pay for it. You gotta pay for all
Yeah,
the,
you have to pay for this.
the chemicals. The lawn care I did.
Okay.
Which we have an HOA issue.
All right. Did you want to say anything else?
Your Honor, just to speak to my client's medical condition, plaintiff is acting like he did not just undergo surgery for cancer. He is still in recovery from that. He does not have the ability to increase his income. Plaintiff has never been certified disabled by anyone. She's attempted several times to receive disability income, and she's been denied each and every time. And so to say that he has earning capacity beyond what he has, and to ignore what her own earning capacity is just ludicrous in this
But
case.
we never alleged that, Your Honor. We said he was retired. We never said that he had earning capacity, so I'm not sure where that comes from.
Well, you said his income was $5,000 a month.
Well, it is, that's per his FDF. I'm looking at his FDF, and his income per his FDF on page 2 is $5,626. That's what he claims his income is. Right here on his FDF, sworn testimony, so. As far as her expenses, Your Honor, at a minimum, she's looking at just between credit card, food, her food, fuel, and dog expenses. So we look at $170 for her credit card. If we say that her food runs $600, which is what he's saying his food expense is, she's saying it's more like $750. If we look at the expenses for the dog, a cat, that's $150. That's not taking into account gasoline, which is another $250 on top of that. So we're looking at a minimum of $1,100 plus $1,200 in just expenses for her at the bare minimum, with no wiggle room at all. And certainly with him having the ability to pay. And again, the mortgage on the rental, the tenant has just given notice. My understanding is that the rent has been paid for this month, and so if they can get the house for sale quickly, there should be next to no problem as far as that's concerned. Also in his accounts, even though he didn't list his TD Ameritrade accounts and just adding them up from the information, the 6-month statements that I was provided, he does have $185,000 in those TD Ameritrade accounts. So he does have access to significant income that my client does not have access to. Those are in his name solely. And that he used one of the TD Ameritrade accounts. It looks like $4,000 was taken out. That corresponds with Mr. McDonald's fees. So he has paid his off, whereas my client has a debt related to the credit card that she put my fees on.
So, am I missing something? I see TD Ameritrade accounts listed, but they all say 0.
They're $185. He just didn't put the amount.
On my client's FDF, they say 0?
Well, they just say nothing.
So that's her account. She listed 0. She doesn't know.
Hang on.
Which is
All right, maybe I.
The numbers at the time of filing.
I'm looking.
Yeah, it's my client's FDF. We didn't have the numbers at the time of filing. My client does have,
It's not accurate.
well, it's not 0, but there's nothing filled in there. My client does have money in the TD Ameritrade accounts. Those are largely separate property from pre-marriage.
Okay, but they need to be on the FDF.
Absolutely, they do, and we'll supplement that as soon as
So
possible.
how much are we talking about?
Council has received statements on all of those. There is $169 in my client's TD Ameritrade account, and then plaintiff has 2 accounts. We have absolutely no information on one of them, and the other one has 25 in it. And she's been pulling from hers.
Yeah. She says no. Not true. Okay.
Well,
What's not true?
She's
Which
been pulling
part?
from hers.
Okay. I took $2,500. I told you.
Yeah.
Okay, so if you look at what all the expenses for the house, if I use the numbers, I mean, I don't know if they're a little high or if you have a really big house, because electric at 400 and gas at 175 seems really high to me.
It's a $500,000 house.
So it's big.
Yeah.
Okay.
31
So with all that the defendant's paying, if you take out the rental, he makes about $4,041 or $4,100 a month, and then he's paying all of these expenses with the house. After he pays those, he's left with about $1,775. Then of course he has to take care of his expenses too. I mean, you both need to eat. You both need to make sure your medical issues are taken care of. I mean, I guess the good news is that you both have some funds that you can pull from. The bad news is that you have to. But with the understanding that the defendant is paying all the expenses associated with the home that plaintiff is going to remain in, at least until the divorce, I think what would be appropriate is that we set a temporary spousal support of $750 a month. And that way, you're both pretty much on even footing. And again, this is temporary. Do you think that it would be beneficial to have a senior judge settlement conference?
I don't know if we'll need to get to that. I think once we exchange.
Do you think you'll be able to do it?
If there wasn't a separate property component, I have faith that opposing counsel and I would be able to work this out.
I haven't seen any of the documents yet, so I don't know.
Let's see there.
How far out are we looking for?
August. Not that far.
And then we just need to give, what, at least 2 weeks' notice if we wouldn't be able to use it, to be able to give it to somebody else? Or
At least.
At
'cause-
least.
Yeah.
do you want to go ahead and set it, and then if we don't need it?
I mean, do you think you're going to use it? If you don't want it, I was just offering it.
I love the settlement judge program, so I mean, if we do have any, spousal might be an ongoing issue because she does not have any income, he does, and she's only entitled to a small portion of his pension, so that could be a sticking point. I don't think it would hurt to have that August settlement judge date, and then if we don't need it, we could always release it back to the court.
If counsel thinks we need it, I've had good success with counsel in resolving cases in the past, so I don't think that's going to be too much of an issue, but.
Yeah, it doesn't hurt, just to have it as a security.
Okay, so then when do you think you'll know if you don't need it?
Well, counsel was talking about getting me something shortly.
As soon as I can.
Okay.
I mean, it's a 15-year marriage, right? And so if we're talking about separate property components, we're tracing a very long time back. So as soon as I can get it, but I don't think I'll have it.
Like in the next
maybe
30 days?
2 weeks,
Maybe next 30 days or something?
potentially.
Yeah, okay.
Okay, so we'll set the senior settlement judge conference. When is it?
August 24th at 9.
August 24th at 9 a.m.
Can I just check that date? I apologize.
Okay.
And that's sooner.
And at this point in time, I'm deferring the request for fees to the time of trial. Should we set a CMC? Because you haven't really.
Yes, we could do that.
You were shaking your head now.
I don't see.
Well, I mean, we're supposed to have
We've
one.
got the settlement conference. Could we set it after the settlement conference?
We could.
I just don't see setting trial dates before the settlement conference if we're going to use.
Well, not a trial date, but the CMC would just be to set the trial date, so we could do the CMC and still set the trial date beyond
No,
that.
that's what I'm saying. I don't see a reason to even set trial dates if we're going to do the settlement conference and potentially resolve it there. That's why I'm saying maybe after the settlement conference.
So you want to have the CMC after the settlement
That's
conference?
fine.
All right, we can do it that way. So how far out? A week or two after?
I would say, within a day or two probably, because if we're not going to use it, we'll just call Your Honor and let you know.
Okay.
August 28th at 11.
All right. What day of the week is that? Okay. All right, so who's preparing the order from today?
You want to go ahead?
Whatever you want.
I'll go ahead. I'll go ahead and prepare.
You'll prepare it and then you'll
obviously-
sign off?
Yeah.
Okay.
Yeah.
All right. Thank you.
Thank you, Your Honor.
Thank you.